Will the clerk please call the next case?
326-0014 Steve Rourke, appellee, versus Next Realty Age LLC, appellant.
Counsel Wixon,
Yes.
you may proceed.
Okay. Good afternoon, Justices.
Good afternoon.
I am Joyce Wixon, representing Next Realty Age LLC in this appeal as the appellant. I'd like to spend the first 5 minutes or so going over the history of the LLC formation and its eventual dissolution, which has led to the controversy in this case. In 2012, the LLC was formed by three principal partners, Jeff Jewell, Mark Whittington, and a fellow named Mike Kleinstub, now deceased. They invested $35,000 of their money to form a real estate brokerage and investment company. But since they were not licensed realtors themselves, under the rules of the IDFPR, they were required to have not just hire a manager, but to have a member be a licensed individual as a realtor. Therefore, Steve Roake joined the company when it formed and was given a 5% ownership interest for a capital contribution of $1,900. Mr. Roake did manage the company for several years. In 2014, the members agreed to purchase a membership in a educational and networking group called Renatus. This was a personal service contract that Mr. Whittington and Mr. Roake still are members of at the time. It was not purchased as a company asset, but as I said, was instead a personal services contract. In 2016, Mr. Roake decided to withdraw from the company and go to work for a competitor, Keller Williams in Naperville. When he did so, his license was terminated at Next Realty Age LLC and transferred to Keller Williams. Therefore, upon his withdrawal from the firm, he no longer became the manager. He was no longer the manager, but he also was no longer a member. And the reason for that is based on the operating agreement, which I did attach to my motion to dismiss and is incorporated into my briefs and appendix in this case. So after Mr. Roake left the company in 2016, the other members decided to join a different brokerage firm. And in September of 2021, there was involuntary dissolution of Next Realty Age LLC. At that time, in a month later, October of 2021, Mr. Roake sent a letter to John Barnick, who was the former manager of the LLC, demanding access to the books and records of the company and his share of the business. But by that time, there were no assets left, and it was too late for Mr. Roake to pursue claims against the defunct LLC. It had been more than 5 years since he left the company, so really any claims that he may have had would be barred by the 5-year statute of limitations for partnership agreements. And I'm going to refer you to the Illinois LLC Act in Section 15-20B, Actions by Members. It clearly states that a right to an accounting upon dissolution and winding up does not revive a claim barred by law. And in this case, the accrual and any time limited for the assertion of rights under the operating agreement or the LLC Act, that remedy was governed by other law, meaning the statute of limitations for partnership agreements. So where are we now? Mr. Roake waited 5 years to make any demand upon the company. He then waited 2 more years before filing suit in 2023 against the former members of the LLC.
Ms.
And
Wixon, how does all this fall? How does the dispute fall within the terms of the arbitration agreement? That's what I think we're interested in.
okay, so let's go to the operating agreement itself. Okay, the operating agreement does state that the act is incorporated into the operating agreement. That's under section 2.7. It also states that Mr. Roake seeks to be a member, and his only recourse here, it would have been selling back his membership interest. Now, Mr. Roake has argued that somehow the statutory obligations under the LLC Act for reimbursement of expenses or loans, for the right to examine the books and records of the company, or to bolster his claim that the former members of the LLC somehow breached a fiduciary duty to the company or to him, all of those would be included in the arbitration because those statutory claims were incorporated into the operating agreement. And the arbitration clause, it states that with respect to any controversy or claim that arises under the terms of the agreement and thus is not resolved through negotiation, the company and each member agree to seek resolution of such controversy or claim through arbitration in DuPage County, Illinois, in accordance with the current commercial arbitration rules of the American Arbitration Association. Those rules are included in my appendix, and they clearly indicate under Rule 7 of the AAA rules that under jurisdiction, it is the arbitrator shall have the power to rule on his or her own jurisdiction, including any objection with respect to the existence, scope, or validity of the arbitration agreement, or to the arbitrability of any claim or counterclaim. This is quite different than under the Illinois or the Uniform Arbitration Act, where the court is given the responsibility to determine the threshold question of arbitrability. And in this case, I believe that Judge Barron had erred in denying my motion to dismiss and compel arbitration because she attempted to interpret the extent of the arbitration clause and decided that it was not broad enough to include the statutory claims under the LLC Act. And my argument here is that that was an error on her part. She did rely principally in the, as you read in the transcript, that under the Keeley and Sons, she determined that the arbitration clause was not broad enough to include the statutory claims. But what's interesting in the Keeley case is that in reality, the arbitration clause is almost identical to what we have here, and I'd like to quote it to compare. Any dispute arising out of the interpretation, performance, or alleged breach of the agreement shall be settled by binding arbitration. There is nothing in that language that says arising out of or related to. And this clause was considered broad enough to include the claims that were being brought. The only reason why the Keeley court decided against arbitration was because there were two separate contracts involved. There was an arbitration clause only in one contract and not the other. Had the arbitration clause included the language or relating to, it could have incorporated the other contract as well and requiring arbitration. But since there was not an arbitration clause in the other contract, and it clearly does not use the language relating to, then the matter was not sent to arbitration. But there are at least two cases where the language is almost identical to our case, both of which were considered broad enough to send to arbitration. And the fact that, it doesn't contain the magic language, as Mr. Gasparo has argued, of relating to, does not really apply. It's kind of a red herring in this case, because when you're talking about matters related to, you're talking about torts or intentional actions that the members have taken, which are outside the scope of the arbitration agreement. It could be tortious interference with the contractual relationship. It could be fraud. It could be conversion of property. All of these rights. There's also a case that has been cited where there's a right to privacy that was the Privacy Act that would be not included in the employment agreement with the airline workers. So we don't have a situation where there is an independent cause of action that I am trying to bring into the case by saying, well, it's related to their relationship as members in this LLC.
Counsel,
Everything,
excuse me, did you say that if the state act applies, then the
yes,
court would determine arbitrability, but if the federal act applies, then the arbitrators determine arbitrability? Is that what you're saying?
yes, exactly,
And help me
exactly.
understand, I'll assume for a moment that I agree with you. Help me understand why the federal act applies here instead of the state act.
Because the federal act applies whenever the AAA rules, the American Arbitration Association rules, are part of the federal act applies um, unless the agreement specifically states that a different arbitration. It can be the Uniform Arbitration Association. It could be the Illinois arbitration, but the rules under the Illinois Arbitration Association or the Uniform Arbitration Association, those two um, statutes do in fact give the court, the trial court, the um, responsibility to determine the threshold issue of arbitrability. It's a very narrow point, but it's a very important one because the FAA, under which the AAA rules apply, encourages arbitration and is much broader in that sense that when, and if I may cite to my brief the Donaldson case, I talked about this where it basically says it doesn't really matter how broad it is if the parties have let me strike that on page 3 of my brief where I was talking about the broader arbitration agreements referred to in the cases are sometimes known as generic arbitration agreements, but um, you know the head count here isn't important as to you really have to look at each case individually. And in this particular case, it is the responsibility. The court is not supposed to be weighing the threshold issue. It is for the arbitrator to decide his own jurisdiction and specifically the arbitrability of any claim or counterclaim without any need to refer such matters first to the court. And I think that's a very important distinction, and which is not the case in the Flood versus Country Mutual case or the Stearns versus Newby case. Those all deal with the Illinois Uniform Arbitration Act, not the AAA. I see my yellow light is on, so I would like to just conclude by saying that, um, under the AAA rules, it is the arbitrator shall interpret, I'm looking at Rule 9, and apply these rules insofar as they relate to the arbitrator's powers and duties. It's really up to the arbitrator to decide if he says, like, no, these are these are claims that are outside my jurisdiction, the matter would be referred back to the court. But in this case, the court decided the issue and, in my opinion, decided it unfairly because clearly all of the statutory claims that are raised by Mr. Roake arise out of the operating agreement because the operating agreement incorporates the act. And that is that. Therefore, I believe it was an error on her part, and I ask that you reverse the trial court's decision and compel arbitration.
Thank you, counsel. You'll have time in reply. Are there any questions from the bench?
Not at this time.
No, thank you.
Thank you. Mr. Gasparo, you may respond.
Thank you, Justice. Good afternoon, Carmen Gasparo for the appellee, Stephen Roake, individual.
Can you turn up your volume a little bit, if you can?
I'll
maybe?
speak closer. Does this help, Judge?
Yes, it does.
Okay, all right.
Thank you.
Good afternoon. Our position is that the starting point and the ending point of the analysis would be the party's intent and the party's agreement, which is located precisely at Section 1311 of the operating agreement. The phraseology in Article 1311 is probably the narrowest and restrictive type of language for arbitrability that's available under the edicts that are set forth pretty eloquently in the Stearns case, where the court summarizes the law in Illinois that an arbitration clause that contains the phrase arising out of the agreement, but fails to also include phraseology specifically or relating to the agreement, then that the court should defer to the party's intent to keep it restricted to what they said in the agreement, which is basically, in this case, the parties only agreed to arbitrate any controversy or claim that arises under the terms of the agreement. It didn't even say arises out of this agreement, because that could be even broader than arises under the terms of the agreement.
Counsel, it seems like a really artificial and rigid standard if you're going to distinguish between arising out of and relating to, and you've got to have, you're saying you have to have both. If you only have arising out of, then the court determines arbitrability, and if you have relating to, then arbitrators determine it. Is that what you're saying?
Well, I think that arising under the terms of the agreement there's a shade of distinction between that and arising out of the agreement. I think arising out of the agreement has a broader focus. It could incorporate concepts such as the implied covenant of good faith and fair dealing that's in all contracts, or there's other things arising out of the agreement. Under the terms of the agreement, terms is a specific English word that means the stuff that's in the agreement. What does this provision provide? What does this provision mean? Has this provision been violated, right? Terms of the agreement is different than arising out of the agreement. But I don't think we have to drill down that deep, because it also does not include or relating to the agreement, right? It's deficient in that second, I think, in more important way. It doesn't broaden the scope into things that relate to the agreement. It is very strict. Arbitration will be for claims or controversies relating to the terms of the agreement. I think as practitioners, we take these provisions very seriously. There are times when you're advising clients that you may want to avoid courts because they can be expensive and resource consuming. On the other hand, there are times that you want real judges. You don't want an arbitrator. You want serious judges and stuff that can people that are equipped to handle serious topics under rigid rules of evidence with experience in resolving claims and controversies. I think that the claims that Mr. Roake brought forth in his complaint would be just such those claims. He alleges breaches of fiduciary duties, and he is claiming that the LLC owes him money back as a refund of funds paid in excess of his capital contribution. I think that, put another way, if the complaint was not raised in 3 counts under the LLC statute, it would have had to have been brought as a breach of a contract complaint. And the contract, of course, would be the LLC agreement. And nothing in the LLC agreement would have availed him in the recovery or the remedies that are sought, that are provided by the Illinois LLC Act. There's nothing in the agreement that provides that he is entitled to the records that the LLC compels the LLC to provide upon demand. The LLC has the specific provision concerning the refunding of claims brought over and above the capital contribution. That's section 15.7a. And ultimately, we would not want an arbitrator, I would think, to decide whether or not the parties committed the relatively serious and complicated legal infraction of a breach of a fiduciary duty. The LLC could have, but it didn't contain provision that explicated or added to the fiduciary duties that are pretty competently and coherently set forth in the Illinois LLC Act. So given that we could not have brought this as a breach of contract complaint, I think that causes the inescapable result that it was brought under the provisions afforded to Mr. Roake under the Illinois statutes. I don't agree that just because the LLC agreement has a provision saying that its terms will be governed according to the Illinois LLC Act, that necessarily is the open door or the vacuum that draws in or sucks in the concept that therefore any claim that is brought under the act is therefore an implication of a violation of the LLC Act. I think that's far too broad, and it would lead to results that would be nonsensical. The parties agreed, again, in 1311, what they decided they wanted to arbitrate and what they did not want to arbitrate, including the topic of who should decide whether there should be an arbitration, whether it should be a real judge or whether the arbitrator should decide. And the law, again, in Illinois, it set forth again, Saltitz versus Christ, tells us that the courts should not assume that the parties agreed to arbitrate arbitrability unless there's clear and unmistakable evidence that they chose to do so. I think this leads me to just a general concept, and that is, I believe it's the courts, and I'm not a judge. I believe it's the courts. I've heard it be generally speaking, the court's philosophy that the courts are not there to resolve everything and resolve everybody's disputes. It's only there to resolve things that the parties themselves could not handle themselves. In this case, the parties did set forth a pretty explicit agreement of what they ascertained what would be arbitratable and who would decide arbitrability. There's nothing in the agreement that makes it clear otherwise. I think the court would be
Mr. Gasparo, let me interrupt if I may, and just ask this question. In Donaldson, they go through basically 3 different scenarios in terms of who decides arbitrability. And the third one is essentially this idea where the parties disagree as to arbitrability, which of course we have here. And then the question of the party's intention as to such scope is reasonably debatable. And in that circumstance, arbitrability is initially determined by the arbitrators. I guess my question is, why aren't we in that situation? Isn't, as I understand it, aren't we in a circumstance where the question of the party's intention is reasonably debatable?
Thank you, Judge. I think I would have to disagree that the party's intention is anything but clear and unambiguous. The agreement says what they agreed. And they said with respect that arbitration will occur with respect to any controversy that arises under the terms of this agreement. And it could have, but did not say anything further. So there, at this point, we were told by the parties that only the terms of this agreement are subject to arbitration. Voting, whether somebody had to violate a principle of the quorum requirements. If there's a term, and that's the word that they used, if there's a term in this agreement that somebody violated, then we go to arbitration, but not otherwise. And I think that to call it ambiguous as to whether or not they intended to defer the question of arbitrability, I think ignores some of what is covered by that arbitration clause in the first place. It's very restrictive, and it makes it clear that everything else but for the terms of this agreement, the parties go to the real court and seek help from the real judges.
So you're effectively saying it's a slam dunk in your client's favor.
Well, my response to Justice Brennan was simply that I think that the ambiguity has to be implied, or at least that's the inference that I'm asking the court to agree with, based on the fact that the arbitration phraseology is so restrictive under the Stearns rubric. And last of all, I don't agree that just because the operating agreement provides that arbitrations will occur in accordance with AAA arbitration rules, carries with it the added implication that therefore the arbitration rules will govern whether there should be an arbitration in the first place. It's basically a chicken and the egg problem. Which comes first? I believe the operating agreement is telling us pretty clearly that once you get to arbitration, then the rules will be the AA rules will be followed. It doesn't tell us what happens in terms of how or if we even go to arbitration. And I think by implication, the same reasoning holds with respect to the FAA. I disagree that because the FAA carries with it provisions regarding arbitrability, that should necessarily override the party's clear and unequivocal statement in their agreement as to what they feel should be arbitrated and what they agreed should not be arbitrated.
The parties' agreement incorporates all of the AAA rules, not just all of them except the ones involving arbitrability. Fair?
Yes. Well, but again, I think it's a matter of time, right? So the question is, what happens first? What happens second? What happens third? The first question, before you even talk about whether or not AAA rules apply to this LLC operating agreement, you have to get past the question of whether or not the the controversy in front of the court is subject to the arbitration clauses, right? So if it's if one of the members violated the edict set forth in the operating agreement that restricts certain conduct or compel certain conduct, and that term of the operating agreement was now a source of a conflict or controversy or claim as set forth in 1311, that's an arbitration. Once you get there, Justice, then you go to AAA, and then AAA is open. Is now the playbook for that resolving that disagreement.
Thank you, counsel.
In the end, since the LLC, our legislature in its wisdom has set forth a pretty clear and coherent LLC Act. It's a resource. And it serves as the underpinning of every single count in Mr. Roake's complaint, with reference to a very specific provision that gives him the basis and the privilege to ask for the courts to intervene on his behalf in the claim or controversy. The parties did agree in their operating agreement to seek arbitration under very restrictive terms. I'm taught by my experiences and my observations of courts is that it's wise to keep the agreements of the parties right where they belong, in their hands. In other words, I'm told that Abraham Lincoln is credited with the statement, going to court is a failure. It's a failure of reasonable minds to figure out how to resolve an agreement or figure out how to solve a problem. I think by reverse inference, then the courts are also have the same message for its potential parties. When you agree to something, if once you've made that agreement, you're both bound by it. But you have the right to expect that agreement will be not adjusted, notwithstanding the power of the courts, but will be left alone between you and the person that you contracted with.
So I've let you run over in time. I was thinking
Okay.
some summarizing, but I didn't hear it. So would you quickly summarize and conclude?
No, that was my summary, Judge. I have nothing further.
Okay.
I was not. I did not see my light. I apologize.
It's kind of hard to see. Okay. Any questions from the bench for Mr. Gasparo?
Not for me.
No, thank you.
Counsel Wixon, you may respond. Reply.
Right. First of all, I would like to address the argument that somehow the operating agreement does not incorporate the statutory provisions of the Act. And I'm referring you now to 508 ILCS 180/15-5. It talks about operating agreements. And in the very first paragraph A, it says, to the extent the operating agreement does not otherwise provide, this act governs relations among the members, managers, and company. And then it goes on to talk about the duties and what the operating agreement may not do, what the operating agreement may do, which is to restrict or eliminate a fiduciary duty. It may also alter or eliminate the right to payment or reimbursement of a member provided under Section 15-7, and may limit a member or a manager's liability to the liability company for money damages. So clearly, by the incorporation of the LLC Act, it is part of the agreement, even though counsel does not wish to acknowledge that. And I also want to point out that the Stearns decision is an unpublished decision from the Fifth District. And I don't believe it's precedent here, but I want to read just the last paragraph. The claims alleged in Stearns' first amended complaint are breach of fiduciary duty, conversion, tortious interference, aiding and abetting fraud, and civil conspiracy. These do not fall within the scope of the narrow arbitration clause. The operating agreement does not contain provisions relating to fiduciary duties, conversion, tortious interference, fraud, conspiracy. Those claims are clearly outside of the operating agreement. And under those circumstances, and this was, the Stearns case was under the Illinois Arbitration Act, you can understand why the court said, well, those tort claims and fraud claims, those aren't part of this agreement, and they might be related to, but since it doesn't contain that related to language, we're not going to hold it broad enough to send the matter to arbitration. It's clearly distinguishable on its facts, and I think the more persuasive case, which is a second district case, the one I quoted, Wine Tech Inc. versus Light Switch Investors, in my reply brief, it talks about how the one party did not want to arbitrate and had 4 or 5 different claims. And the bottom line is they said, I don't care what you call them, they are still all of, it talks about the LLC Act is incorporated into the operating agreement. So the purportedly purely statutory theory indeed gives rise to disputes over the manner in which the operating agreement is to operate. And that is my my argument here. And if you look at what the Wine Tech decision, the issues involved in that case, it's on page 4 of my reply brief. It's the manner in which the agreement is to operate, subject to arbitration. The arbitration had 5 counts. The first asserted the plaintiff was requesting an accounting or valuation was time barred under section 13205. The second count asserted that plaintiff disassociated from the LLC when he resigned his job and expressed his intention to withdraw from the company. That's clearly the situation we have in the case at bar. The third count related to transfer of his membership interest at the appraised value. That's also part of the operating agreement. And the fourth count asserted that his ownership interest was terminated under the operating agreement. And the fifth dealt with enforcing the terms of the settlement. And they said, regardless of what you want to, whatever the specific theory underlying any one of them, they were within the parties' overall dispute about the functioning of the operating agreement. And it quotes, our conclusion is undisturbed by plaintiff's attempts to characterize the various counts as disputes over something other than the manner in which this agreement is to operate. I think that clearly these cases support my argument. There is no dispute that that the arbitration clause applies, and under the FAA rules, it is up to the arbitrator to decide the issue of arbitrability and not the trial court. Thank you.
Questions from the bench? Any questions?
Not for
No.
me.
No, thank you.
Okay, thank you. Thank you, counsel, both for your arguments in this matter this afternoon. It will be taken under advisement and a written disposition shall issue. And at this time, the clerk of our court will escort you from our remote courtroom and have a nice